Hey guys, pretty excited to take a look at what we're going to look at today. So, Factual Lie had pinged me in this earlier this morning. There was just like a quick little news post over on Twitter X about an amicus briefing, an amici briefing, filed with SCOTUS in relation to James Broadnax's petition for writ of certiorari to SCOTUS, which is, hey, we're petitioning for you to take our case. We think there's an issue that the Supreme Court of the United States needs to hear. Here's what it is, and we're asking you to say, yes, we'll hear this. With this amicus filing, we have at least in the names, we're going to read all of them. We have Erik Nielson, we have Michael Render, who you guys might know better as Killer Mike. We have Howard Law Criminal Justice Clinic, and other music scholars, artists, and arts organizations in support of petitioner. We're going to read the full list of who's part of this before we get into this. I think that's important. But just as a quick little layperson way of how to look at amici or amicus or amici, there's all different pronunciations for it. They're sort of friends of the court. They're individuals or organizations who they're not parties to the proceedings. They're not James Garfield. They're not with the prosecution team in the state of Texas. But for one reason or another, they find that something that happened in this case that will be part of this petition, if SCOTUS allows the possibility to have it heard, that they think there's greater considerations for. Either they themselves have things that they want the court to be able to think of that the parties might not be raising, or they want the court to think, whatever decision you end up making, if you decide to make decisions in this matter, there's implications that could go beyond this case. And here's some things that we want you to think about in that regard. So the overall arching theme here is going to be the use of rap lyrics. And in this particular case, they were used in the sentencing phase. So we're going to get into the whole argument and see them break it down. They'll do it way better than I am, I'm sure. But let's see who's here. So, category of artists and industry professionals. And, see some familiar names. We've got Kevin Liles. We've got Young Thug, who's on the advocacy side. We have T.I. We have Fat Joe. If you're interested in his lawsuit, we just read Joe Tacopina depose attorney Blackburn in the defamation and extortion suit they've got going on. So check that one out. That was 2 days ago. McKinley Mac Phipps. We have D Nice. We have Noriega. We have N.O.R.E. We have Mad Skills. We have Ebro. We have Anthony Anderson, Mike Curato, Dina Lapolte, Willie Prophet Stiggers, Raina Bass, Shay Lawson. We have organizations that are joining in, these arts organizations. We have Free Our Art. We have Artist Rights Alliance. We have Art Not Evidence. We have Black Music Action Coalition, Music Artists Coalition, Songwriters of North America, and then scholars, a bunch of scholars. So we have Jody Armour from the University of Southern California. We've got Lakita Bonnet Bailey from Howard. We've got Ann Barnes from the University of Minnesota. We've got Regina Bradley from Kennesaw. We've got Lambros Fatsis, sorry if I'm saying that wrong, from City of St. George in University of London. Love to see we are getting international here. We've got Murray Foreman from Northeastern, Antoine Hardy from Seton Hall. We've got Anthony Kwame Harrison from Virginia Tech, Robin D.G. Kelly from the University of California. I should say UCLA, shouldn't I? We have Karis? Maybe it's Charis. I'll say Karis Kubrin from University of California. Jack Lerner. Lots of Cali coming in. Love to see it. Corey J. Miles from Tulane. We have Abina Owusu Bempa from London. We're back with London. We've got more London. And then Emmett G. Price from Berkeley College of Music. Etney Quinn from the University of Manchester. And Dorothy Roberts, University of Pennsylvania. So these are the parties that are part of this filing. Now, who's helping write this? We've got Lucius T. Outlaw. What a name. What a name. That is awesome. So he's a professor of law from the Criminal Justice Clinic, Howard University School of Law. And we've got Charles the Chad Baruch, or maybe it's Barrick, who knows, who's counsel of record here. And this is, let's see, also Brandon Toby, and they are partners, it seems, at Johnson, Toby, and Baruch. So there we go. They are the Texas attorneys here. So here we go. Love things when they're filed with like appeals courts, especially SCOTUS. You get this nice table of contents, and we're not going to read the table of contents, but we're going to look at quick top view of the argument. It's a really great way to get an overview. So one of the things they're going to talk about is the absence of Broadnax. That was the individual that was convicted. The absence of Broadnax's lyrics from the guilt or innocence phase of the trial. They're arguing that it's an admission of their lack of relevance to the facts of the case. So in death penalty cases, there's a guilt phase. Did they actually do the thing, and did the state prove that beyond a reasonable doubt? And then the penalty phase, where it's in the jury's hands to say whether or not the criteria is met. And if yes, then they can recommend a death sentence. And I think most states still allow the judge to consider. I don't know if it's always binding what the jury decides. That I don't know the nuances state by state. Next argument here, the state used Broadnax's artistic expression to stoke racial and anti-rap bias. The next argument, the state weaponized cultural expressions common to rap to improperly portray Broadnax as dangerous and threatening. And then last argument here is there is a judicial and legislative trend toward prohibiting the use of rap lyrics as criminal evidence. So again, this is all, they're submitting this alongside with what's being submitted in what's right now at the petition for writ of certiorari stage. And they're submitting it on the side of James Broadnax, who's the petitioner here. So Broadnax himself will probably, I would say almost undoubtedly, raise different arguments than what we're going to see here. This brief is going to be focused on the issues we just looked at. We're going to skip, we'll read some of the case law as we go, so we're not going to read the whole table of contents word for word. All right, so interest. They're going to tell us why they're interested, and they have a footnote already in the header here for the AMICI. It says, as required by Rule 37.6, AMICI CURIAE state that no counsel for a party authored this brief in whole or in part, and no counsel or party made a monetary contribution intended to fund the preparation or submission of this brief. So they're saying, like, we're not being paid. This isn't an extension of what Broadnax and his team are going to do, or what the state of Texas and their team are going to do. And the reason for that is, I don't know, is Rule 37 like the character limit? They don't want a party to have like a workaround for the amount of words they can submit with their brief. Let's see what that is. Okay, so Rule 37.6. We're going to do a little side story here and read this. Where's 6? Except for briefs presented on behalf of amicus curiae listed in Rule 37.4, a brief filed under this rule shall indicate whether counsel for a party... they just want to know. So they just want to know if its members, if anyone has made contribution to the preparation or submission of the brief, the disclosure shall be made in the first footnote. There we go. So that's just super procedural. Pull up the brief again. All right, so the interests. First, so Erik Nielson is a professor of liberal arts at the University of Richmond. He's published widely on African American literature and music, with a particular emphasis on hip-hop. He is co-author of the award-winning book Rap on Trial, Race, Lyrics, and Guilt in America, and frequently serves as an expert witness in cases involving rap music as evidence. Michael Render, aka Killer Mike, is a Grammy-winning rapper, author, and public speaker. His recent album, Michael, was the most critically acclaimed record of the year in 2023 and garnered 3 Grammy Awards, including Best Rap Album. When he isn't recording or performing, he can be found in television studios or university lecture halls talking about a wide range of issues, particularly those related to race and social justice. We've got the Criminal Justice Clinic, or they're going to shorten this, I guess, if there's any other mentions to CJC, is the experiential legal clinic of the Howard University School of Law, where students represent indigent clients. Those are people that can't afford their own attorneys or resources to defend themselves, charged with misdemeanor offenses in the local court of Washington, D.C. Professor Lucius T. Outlaw III, like the craziest cool name ever. Imagine, pretend you're a lawyer, and your opposing counsel is Lucius T. Outlaw III. Like, oh man. He supervises and directs the clinic. In 2023, the CJC launched Culture Not Evidence, an advocacy and litigation campaign dedicated to stopping and reversing the criminalization of rap music and hip-hop culture by the criminal legal system. The clinic students who assisted in this brief are Tamaya Burnside, Jasmine McMillan, and Jake Smith. Well, that was an easy one. We got a like John Doe name. The views expressed in this brief are those of the CJC and not of Howard University or Howard University School of Law. Additional amici are listed in the appendix, and that's the list that we read. So, summary of their argument. James Broadnax, a 19-year-old black man, was charged with the murder of 2 white victims. During his trial, the state presented a racially charged case filled with stereotypes and anti-black rhetoric. It repeatedly described Broadnax as a predator with animalistic characteristics like those observed on Animal Planet. These are in quotations. So they're quoting the petition that Broadnax filed at 5-6. Broadnax was found guilty and sentenced to death by a nearly all-white jury. But the stereotypes and anti-black rhetoric did not end in the guilt/innocence phase. The state carried those discriminatory themes into the punishment phase and then heightened it by introducing and mischaracterizing over 40 pages of Broadnax's artistic rap expression. This brief focuses on the state's prejudicial misuse of Broadnax's rap lyrics during the sentencing phase. So remember, they're saying, hey, this is the issue we want you to consider. It doesn't mean that other issues aren't going to be raised by, the actual petitioner for the sake of this. And their brief's already been filed. If you guys are interested in looking at that, let me know if I should add it to the to-do list. So the state urged the jury to consider the lyrics as literal rather than metaphoric expressions, and to interpret them as self-admissions of Broadnax's intent to commit future violent crimes. Indeed, the state described the lyrics as Broadnax's master plan, and the events leading to trial as his execution of that plan. The state did not use Broadnax's lyrics in the guilt-innocence phase, an admission they lacked relevance or nexus to the charged offense, the facts of the offense, or Broadnax's intent, motive, or plan to commit it. Instead, the state used Broadnax's artistic expression in the punishment phase to portray him as living and pursuing a gangster lifestyle that made him a continuing criminal and violent danger to the community. So one of the tick boxes there, to get to the recommendation for a death penalty. The state's use of Broadnax's artistic expression was racially charged. It used his lyrics to appeal to the jurors' racial and stereotypical fears of young black men and rap music. In doing so, it capitalized on the jury's apparent lack of understanding of rap music and the biases and stereotypes about rap music and artists common in American society. And they cite here the threatening nature of rap music, and it's a psychology publication. That sounds interesting. They cite here Adam Dunbar writing for Rap Music, Race, and Perceptions of Crime, which is, let's see if I can open this and link this real quick. That one has a link, so can we see it? Cool. Can we see the full text without needing to request it? All right, sometimes you can get the full thing by writing to the author, but real quick, what this was about that they're citing here. Scholars who study rap music have long expressed concerns that criticism of the genre is inextricably linked to stereotypes of young black men in the United States. Yet, minimal research has empirically examined how rap music is linked to race in ways that legitimize and maintain anti-black attitudes, particularly attitudes related to crime. This article reviews how scholars have typically challenged seemingly racialized concerns about rap music before surveying the handful of studies that empirically examine attitudes related to rap music, race, and crime. I like these types of papers because I don't have the full thing in front of me to show me, but these types of academic papers, they curate a bunch of other papers that are available on the subject, and they kind of compile and do a big picture overview of all of the available research or relevant research. So it's really informative. It's like everything is brought together. So if you just want to dive into something, this would be the right place to do it. And so doing so, this essay highlights a growing need for broader conceptualizations of race, ethnicity, and social control. So there was that. Let's get back to the brief. So, ignoring the lyrics' artistic form and intent, the state portrayed them as literal expressions of criminal intent to appeal to the stereotype that black men like Broadnax are violent criminals. The state further compounded biases and fears triggered by Broadnax's lyrics by comparing him to predatory animals. And this is a different position in the petition, so I wonder if there's even more. That's the type of thing that really makes me want to read the petition. Broadnax's, because I'm assuming they're in the petition, they're quoting from transcripts from the record of trial. Broadnax's lyrics made the prejudicial impression intended by the state. During their one-day deliberations, the jury asked to review the lyrics twice, including just hours before sentencing Broadnax to die. The state's misuse of Broadnax's artistic expression during the sentencing phase was an unconstitutional appeal to the sentencing jury's biases, misperceptions, and fears about rap music and artists. This misuse, combined with the state's portrayal of Broadnax as a super predator and an animal, blew through the strictures of due process, equal protection, and justice. So now we're going to get into argument. You guys. This isn't a ruling. This is or unless you're talking about something that was cited, but this is an AMICI briefing that was just filed. So the status of this case, they're still petitioning for a writ of certiorari. So we don't know if SCOTUS is even going to hear the case. And I'm sure you know, Max, but again, for anyone that's, trying to become a level 2 layperson like myself, right? I'm not a level 1 layperson anymore. I think I've graduated to like 201 layperson understanding of the law. They can file these briefs to say, hey, court, we really think you should hear this case, and we also want you to consider these issues. So please, please, please give them grant their petition for writ. So let's see. I just want to say hey to everybody coming in. I don't mean not to say hey. We're doing 3 streams today. We're going to be watching the state appeal the dismissal of a murder case at the Michigan Court of Appeals. We're going to watch those oral arguments after this stream. So that'll be the 3rd one for the day. Loaded docket here. So, and then let's see. The rise of rap and hip hop. It's 2026 and one thing is undeniable. Hip-hop has transformed from a little-known counterculture that took shape in the South Bronx more than 5 decades ago into one of the most important forms of cultural expression in American history. This is particularly true of rap, the musical element of hip-hop culture, whose rise has been described as the single most important event that has shaped the musical structure of the American charts since the 1960s. And here they're citing the evolution of popular music, so that's fun. All this stuff seems fun. Let me see if I can just... Let's see if this is available, and if it is, drop. Well, actually, you guys, if you want to check out any of these things, the brief is linked in this video. That way I don't have to share each of these links one off, but they are clickable. So if you want to check out any of these individual things here, just pull up the brief and then find the thing that you want to open up. Otherwise, I'm going to be spamming you guys with like 20 links. For years now, rap has been the most listened to genre in the United States. This is from How 50 Years of Hip Hop Provided 50 Years of Marketing Game, which was published in Forbes. So that might be an article. It helped fuel a multi-billion-dollar hip-hop industry that can be seen and heard virtually everywhere, in fashion, film, advertising, politics, and our everyday lexicon. With this success, it has offered countless people, particularly people of color, an opportunity for upward economic mobility in communities where such opportunities often are all too rare. And this is from Rap on Trial. Oh, and yeah. So, and I don't think... So Andrea Dennis isn't part of this, but, just another name to put in there when we're talking about Rap on Trial. That's cited pretty often. Doug Weinstein talked about it a lot. I think a lot of people... we should have done like a little reaction to that for anyone that got that book to read it. One reason for rap's popularity is that it is known for shattering taboos, sending up stereotype, and relishing risque language and subject matter. This is from The Anthology of Rap, a foreword written by Henry Louis Gates Jr., and the book itself is by Adam Bradley and Andrew Dubois. This is particularly true of the, quote, gangster rap subgenre that was first popularized by artists like Ice-T, N.W.A., Tupac Shakur, and Snoop Dogg, and is still popular today. Gangster rap draws on the established tradition of the bad man in African American storytelling, seen in the urban fiction of authors like Iceberg Slim and Donald Goines, and the blaxploitation films of the 1970s, traceable to the toasts of the 19th century and beyond. These toasts, which emerged out of the Black communities in the Jim Crow South, were orally transmitted stories, often told in rhymed form and from a first-person perspective, that celebrated the exploits of a larger-than-life figure. Replete with profanity, some stories, including the well-known story of Stagalowie, versions of which were performed by Bob Dylan, Woody Guthrie, and James Brown, among others, reveled in exaggerated depictions of sex and violence. Created during a time when, quote, inappropriate Black expression could be severely punished, including by lynching, these tales embraced and even doubled down on stereotypes that many white Americans held about Black men, namely that they were hypersexual and prone to criminality, and transformed them into a form of entertainment and, in flouting white sensibilities, resistance too. A century later, gangsta rappers began using their rhymes and music to celebrate the outlaw figure and, like the toast, to reject traditional constructs of, quote, legitimate American life. Gangsta rap became highly controversial for its graphic depictions of violence, criminal behavior, and sexual conquest, which often were patterned after the pimps, hustlers, and gangsters found elsewhere in Black and mainstream popular culture. These criminal figures became emblematic in gangsta rap music and were, quote, elevated to the status of hero. And this is from Kickin' Reality, Kickin' Ballistics, Gangsta Rap and Post-Industrial Los Angeles from Robin D.G. Kelly, who's one of the AMICI here. And we've got Droppin' Science, love it, Critical Essays on Rap Music and Hip-Hop Culture from William Eric Perkins. This elevation happened in part because throughout Black culture, these individuals always have been viewed as a rare example of Black authority over his domain. That's from Nelson George, Hip Hop America. The accompanying sense of power, routinely and systematically denied to Black men, would have been especially elusive during the 1980s and 1990s, the heyday of the war on drugs, and the resulting incarceration crisis that decimated Black communities and saw record numbers of Black men warehoused in prison. Ooh, I like the wording there, warehoused. Indeed, gangsta rap emerged because of, and in response to, increasingly aggressive policing of communities of color across the nation by law enforcement. The desire to project a sense of authority, even if fictional, helped explain the rise of gangsta and other subgenres of rap that featured violence and criminal behavior. They allowed young men of color to create a poetic world in which they were masters of their environments, often perceiving themselves to be social outcasts or targets for policing and institutional discrimination in the real world. They crafted a form that gave voice to the conditions of urban America that many people were not willing to confront, all while reconstructing themselves as figures of power within these urban spaces. Audiences responded to gangsta rap's dark, sordid, and realistic-sounding tales of urban life. It quickly became the most popular and profitable subgenre of rap, spreading beyond the borders of the U.S. and becoming influential across the globe. As a result, beginning in the early 1990s, record companies started moving away from the politically conscious music that had once helped define mainstream rap and started pressuring new acts to adopt gangsta-type rhetoric, a trend that continues today. A long line of successful performers began adopting a commercial gangsterism. Commercial gangsterism is the way to put it. Essentially, a persona manufactured by artists and music producers who had no meaningful connections to gangs or street life, but needed to conform to gangsta conventions to secure recording deals. And this is quintessentially, this one little sentence here was the heart of the argument that we watched in the YSL trial with, this is a record label, this is for music, this is for the fans, this is to sell the records. It's just fiction. So, see Imani Perry, Prophets of the Hood, The Politics and Poetics in Hip Hop from 94. So that was written in 2004, but seems to focus in on 94. Hence, although keeping it real, providing authentic accounts of oneself in the hood, long has been the mantra of gangster rap. It often is a marketing pose reproduced by performers who have limited connection to the lives they rap about. We've got Craig Watkins, Hip Hop Culture and the Production of Black Cinema, 185. Even rappers who do not come from the environments they depict in their music acknowledge their tales are not to be taken literally. For example, and I'm thinking of that, I forget the case. I think it was a Georgia case, though. It was one of the YSL defendants that was severed from the first trial. Was it Demikian Garlington's attorney? But there was a footnote, and it was like, Nicki Minaj did not, in fact, literally shit on them. And quoted her lyrics as an example of why you shouldn't take lyrics literally. But they say here, for example, Jay-Z, well known for dealing drugs on the dangerous streets of New York, before becoming an established musician, criticizes people and courts for reading rap as autobiography. He sees this misreading as the failure or unwillingness to treat rap like art, instead of acting like it's just a bunch of, I'm not saying that, reading out of their diaries. So we've got gangsta rap as both an art form and a heavily marketed commodity. As such, it comes with artistic and commercial expectations. Exaggerated tales of violence, sex, and criminal behavior sell to a broad swath of Americans, and any would-be gangsta rapper must learn and practice these conventions of the form. Equally important, audiences understand rap music is, like gangster films, Western movies, horror novels, or even pro wrestling, a type of entertainment. Hey, wrestling's 100% real, what do you mean? Rap in particular resides within a tradition of Black expression and storytelling going back centuries and a global tradition going back millennia. It frequently is told in the first person and is often advertised as real, making it easy to mistake the genre for a kind of musical autobiography, documentary, or journalism. But it's often complex rhyme schemes, rhythmic emphasis, and reliance on figurative language, not to mention artists' almost universal use of stage names, are the most obvious cues that we should not read it literally. We certainly don't do so with other genres of popular music. In Folsom Prison Blues, country artist Johnny Cash famously sang, "I shot a man in Reno just to watch him die." Another first-person account, don't clip me saying that. I shot a man in Reno. No, I didn't. Another first-person account of violence recorded by Cash, Delia's Gone, includes lines like, "First time I shot her in the side. Hard to watch her suffer, but with the second shot she died." That's also Johnny Cash. Cash, of course, was no more guilty of these crimes than Eric Clapton and Bob Marley were of killing police officers when they recorded their respective version of I Shot the Sheriff. Eric Clapton, I Shot the Sheriff, they're just citing the songs here. For that matter, no one ever assumed that Hall & Oates were stalkers, that Beyonce stole a Lexus, or that the Tramps burned down buildings. Harvard University professor Henry Louis Gates, Jr. once described rap as a new vanguard of American poetry, and noted that it manipulates language to the point that it complicates or even rejects literal interpretation. Let's see. So a literal reading of rap in any of its subgenres does the art form and its creators an injustice. Yeah, so somebody add that clip to the FetLife clips. That was quite the reading stream. And this is precisely the injustice to James Broadnax that occurred here. So B. So now we're getting into, we just went through the history. And isn't it interesting? I always think it's, like, it seems like that was really quick, right? But I feel like it takes a lot of work to condense something down, to make it, they put so much in that. So when we read things like this, we're seeing like a bunch of people work together with a complex argument with a ton of different examples, curate it down, and it takes a lot. I do copy editing, so that's when you hear me saying I've been working on this stupid training manual, textbook, guide, resource thing for work. Writing it is one thing, but now I've been copy editing it and revising, doing the revisions, deciding if it's good and needs a tweak or if I need to completely rewrite something. And it takes forever to do that part, way longer than actually writing it. So we've got the absence of Broadnax's lyrics from the guilt-innocence phase is an admission of their lack of relevance to the facts of the case. This is going to be their first argument here. The state did not rely on Broadnax's rap lyrics to prove he committed the charged crime. It is unclear to AMICI, or AMICI, wherever you're watching, wherever you pronounce it, whether that was by choice or court ruling. Regardless of the reason, the absence of the lyrics during the guilt-innocence phase is not surprising for two key reasons. First, nothing suggests the lyrics were anything other than fictional artistic expressions, period. They cite here Hart v. State. It's a Texas criminal appeals case from 2024, explaining that the lack of demonstration that the lyrics were representative of appellant's character, applied outside the artistic rendering, or were relevant to the charged offense, weighed heavily in favor of their exclusion. Second, Texas courts frown on the use of rap lyrics as evidence when they fail to make a fact of consequence in a criminal case more or less probable. So, quote here from the same case, they don't convict people for murder simply because they have written lyrics about drinking, guns, or murder. That's citing United States v. Stuckey, and accordingly, courts require that the evidence at a minimum be relevant to the case. Indeed, the absence of the lyrics during the guilt-innocence phase was a tacit admission by the state, or the court, that they were not relevant to the question of whether Broadnax committed the charged murders. not even to whether he had the motive or intent to commit them. And then they're citing here the Texas Evidence Code on relevance, allowing other act evidence to prove motive, intent, preparation, or planning. And then also a case here, Com v. Gray, which is a Massachusetts case, explaining that a rap video was minimally, if at all, probative. The state used the lyrics during the sentencing phase purely as bad character evidence to portray Broadnax as having a violent and criminal nature, requiring imposition of death. Now, we're going to read 404A1. It's from the Texas Code, but I wonder if this just adopts the federal language. Prohibiting bad character evidence. As shown herein, this use of rap lyrics was an appeal to racial prejudice, especially the young black male super predator trope, and an anti-rap bias that violated Broadnax's constitutional rights and the foundation of fairness that should accompany criminal proceedings, especially death penalty cases. Next, we have the state used Broadnax's artistic expression to stoke racial and anti-rap bias. There's a quote here, it's a big quote. The central purpose of the 14th Amendment was to eliminate racial discrimination emanating from official sources in the states. That's McLaughlin v. Florida. That's 1964. Over the years, the court noted that racial discrimination in the jury system posed a particular threat both to the promise of the 14th Amendment and to the integrity of the jury trial. And that's Pena-Rodriguez v. Colorado. As a result, time and time again, this court has been called upon to enforce the Constitution's guarantee against state-sponsored racial discrimination in the jury system. Yeah, and this state-sponsored racism is backing what harm, what outcome, right? The ultimate outcome here was the imposition of a death sentence, right? So it's not like, oh, but so what? It didn't actually do anything big. Yeah, this is big. So the court has answered the call because permitting racial prejudice in the jury system damages both the fact and the perception of the jury's role as a vital check against the wrongful exercise of power by the state, the ultimate power to sentence somebody to death. In doing so, it has established the unmistakable principle that discrimination on the basis of race, odious in all aspects, is especially pernicious in the administration of justice. The state's use of Broadnax's lyrics to obtain a death sentence runs afoul of the 14th Amendment and this court's guardrails against racial prejudice infecting juries. In seeking the death penalty, the state used Broadnax's rap lyrics to appeal to racial and anti-rap stereotypes and biases. The triggered biases and stereotypes were valuable to the state's portrayal of Broadnax as a super predator with a violent nature that necessitated putting him to death. So, and this is, let's see, Jasmine B. Gonzalez-Rose, racial character evidence in police killing cases. That seems like, covers a lot of cases where this stuff might be relevant. So that seems interesting. I think I want to look at that one. We've got particularly pernicious is reliance on the black brute or thug stereotype, which casts black youth as super predators and black people of all ages as bigger, stronger, and more aggressive and threatening than people of other races. And this is from Vincent Sutherland's Youth Matters, the Need to Treat Children Like Children. We've got discussing the depiction of young black males who commit violent crimes as super predators, from Robin Walker Sterling, Children Are Different, describing how the fear of young black super predators spread like a fever. So then, considering these exchanges between the state's attorney, we got transcripts, you guys. Consider these exchanges between the state's attorney and prosecution witness Erik Nielson, a Dallas police officer. So, state's attorney, the prosecutor asks, all right, when you look at those lyrics and form a general perspective, so they're asking a police officer. So I don't know if they qualify him as an expert or they're just in his experience as a police officer, but this testimony is coming from a police officer. So when you look at those lyrics and from a general perspective, is the general theme of those lyrics robbing, killing, and selling dope? Yes, sir, that's all it's about. Is that all consistent with the gangster disciples making money? Yes, sir. And then, yes, sir, he's writing lyrics to songs that he's coming up with. Okay, these are things that he would be creating in his mind, though? Yes, sir. Are they like equating writing lyrics as like mental state? of someone committing the crime. The goal was to use the lyrics to conjure the image of a young black thug violently preying on the community. If any doubt remains, this preamble to a question posed by the state during the cross-examination of Gary Aaron, a defense witness, removes it. So, prosecutor on cross of Gary Aaron, and your cousin here, who you say is not dangerous, after he murders these two people, he writes a freestyle about why he's in jail, okay? And he says, check the lyrics, say, look, fade him, tape him up, I hit him later, I'm so high up and cloud-proof, like a skyscraper. Hog tie him and body bag him, send them to the mayor, then I bomb the whole country, send the press, the paper. Well, did this guy bomb the whole country? Like, this is the thing. If we're supposed to take this literally, like, did this happen? Because he's claiming it happened. And that's my never-ending, it's just like, logically, it's so stupid. Anyway, so yeah, they do all that at trial. These lyrics are irrelevant and lack any factual nexus to the case. The state's purpose in highlighting them was to trigger anti-rap biases and black super predator fears among the sentencing jurors. I almost said super jurors. Dunbar, Kubrin, and Skurish, discussing multiple empirical studies showing anti-rap bias and its potential impact on juries. Dunbar, which surveyed, I think that's the one that we looked at earlier. They're citing here also to CURIAE Be Fried, What an Awesome Name, Who's Afraid of Rap, Differential Reactions to Rap Music, all of this stuff, bunch of sites. Reporting on 2 experiments showing that rap lyrics receive more negative criticism than lyrics of other music genres. In examining witnesses during the sentencing phase, the state asked many questions about gangster rap to stoke and reinforce anti-rap bias and fear among jurors. So, here we go. This is during the sentencing phase. State says, is it common in gangster rap music to talk about murder? They ask, it's something you hear on a regular basis in gangster rap. Is murdering other folks? ? And then another question. I mean, you've seen the rap, and you know from the gangster rap mentality that you can get the money any way you can. The world is a bee. You never heard that? The state's misuse of Broadnax's lyrics to characterize him as a super predator and thug continued during its final arguments to the jury. The state told the jury, now, promiscuous sexual behavior. Well, you know, he refers to every woman you've ever heard him talk about on any of those videos or any of his writings as bitch. That's how they said it at trial. Tethering Broadnax's use of the word bitch to sexual promiscuity was a dog whistle to the nearly all-white jury that Broadnax is a black sexual predator intent on having sex, consensual or not, with women in the jury's community. So, put him away forever, the ultimate sentence, get him out of the community is the underlying call to action that the state was making there. This disturbing trope long has been used to imprison black men and send them to death when rape was a capital offense. They say, see Floyd v. Weatherspoon, the devastating impact of the justice system on the status of the African-American males. We've got death penalty for rape, cruel and unusual punishment, ? And speaking partial truths and preserving power, deconstructing white supremacy, patriarchy, and the rap corroboration rule in the interest of black liberation, which discusses how black male sexual... Can you hear me? I just gotta... Alright, my sound gave me an error. StreamYard, this is the second StreamYard error. Alright, can you guys hear me? Okay, we got a can. So we're gonna keep going. Alright, I got a big red error message from StreamYard. I'm learning to see them when they come up. So we've got... Where were we? There's been an enormous danger of injustice when a black man accused of raping a white woman is tried before a white jury. Of the 455 men executed for rape since 1930, 405, or 89%, were black. In the vast majority of these cases, the complainant was white. In making the final appeal to the jury that no mitigation existed to warrant a life sentence, and that Broadnax was a continuing violent danger worthy of the death penalty, the state's attorney used Broadnax's lyrics to trigger the nearly all-white jury's fears of a black super predator. So here's a transcript. And when you think about the defendant's character and his background and the moral blameworthiness, remember who he is. He's a gangster disciple. He told what he was going to do in writings before he even did it. He talked about the murder, before he even did it. He talked about the murder and robbery of people. And you know what? Maybe if he never got out and did it, maybe he'd just be another gangster rapper. But then he went out and did it. Counsel says he wants you to kill him because of what he says he's going to do. Counsel says we want you to kill him because of what he says he's going to do. But you've got evidence right here that told you what he was going to do, and then he went and did it. That's what you need to consider, folks. And then after he does it, and he's in jail, he's freestyling now. He says, hold up, stop and rewind. A little story while I'm in this bee. Yeah, I hit the lick. I got 2 murder charges on me. I might just go to the judge and tell him I'm going to murk him because I'm JB. And then this is emphasized here. This is back to the argument from the state prosecutor. If that's not the sign of a psychopathic killer, I don't know what is, folks. So this lyric, they're saying that this lyric is the sign of a psychopathic killer. And it's such a good example that I don't know what would be a better example. That's what the state's arguing. So, also, Greg, thank you for being a member. Thank you for being a member for 7 months. Don't thank me for reading this. It's something I would read anyway, and I'm like, just going to start doing streams, so anyone that wants to hear me read it can do it. Anybody that prefers to listen and doesn't want to use like a auto reader voice to do it, I'm here for you. So you're welcome. My pleasure. Thank you for supporting for 7 months. We've got back to the argument for the AMICI. So the state stoked and relied on the black super predator trope and anti-rap bias to argue that Broadnax's artistic expression proved his propensity to commit future violent acts and the absence of mitigating circumstances warranting life in prison instead of death. The state achieved its goal with the lyrics because anti-rap bias is prevalent. Multiple studies confirm that people associate rap music and artists with criminality, violence, and other societal harms more closely than they do other music genres, especially those dominated by white artists, and artists of other musical genres, including white artists. In a groundbreaking 1996 article, psychologist Carrie Fried presented the results, maybe it's Fried, but Carrie Fried sounds so cool, presented the results of an experiment where 2 groups were presented with the same lyrics from a song by a white folk group. One group was told the lyrics were rap lyrics, the other that they were country lyrics. Fried questioned each group about the lyrics and explained that even when asked specifically to judge only lyrics, other factors such as the genre of music or the race of the singer played a significant role in reactions to musical lyrics. The exact same lyrical passage, which was acceptable as a country song or when associated with a white artist, becomes a dangerous, offensive song in need of government regulation when it is a rap song or associated with a black artist. While responses to the white artist or country or folk music tended to be on the favorable side of the scale, responses for the black artist or rap music tend to cross over to the unfavorable side of the scale. What a simple yet powerful study. Just like, hey, we're going to give people the same 2 sets of words, and we're just going to say, we're going to give it a different contextualization and watch if the perceptions are the same or if they're different. And there you go. Also, we got Doug in the building. Good to see you, Doug. He says, rap lyrics are my hobby horse, as you know. Good to see you. He says, why didn't I know about this? I didn't know about it until Factual Lie, who you might know, might be late. She might just be listening in. But Factual Lie, who you might know from the chat and over on X, named as O'Bailey's, tagged me in this. So that's the only reason I found out this morning. So the petitioner is still waiting. They're at the writ of the petition for certiorari stage. So maybe this will keep going and you'll have plenty more to follow. But that means there's also a brief. If you want to read the brief from the petitioner themselves, since this is just from the AMICI, there might be more out there. I might do a reading stream on that one. But good to see you, Doug. Hope you're doing well. There's a link to this filing in the description. And a lot of the stuff that's like a link to like an academic journal, it's clickable. It doesn't look clickable, but anytime they're typing a link, it's clickable. So you can get right to it. So we've got, let's see. I just finished this, right? I think I just finished this. Yeah. And that again was from Fried or Freed, Bad Rap for Rap. The experiment further demonstrated that the same lyrical passage is rated as significantly more negative when it is identified as a rap song as compared to when the lyrics are identified as either country or folk, and that when the lyrics are identified with a black artist, the lyrics are rated more negatively than when they are identified with a white artist. So they say, who's afraid of rap? Building on similar studies, Fried concluded that rap music, which is seen as a predominantly black form of music, may be judged through the tainted lens of a black stereotype, which includes such traits as violence, hostility, and aggression. More recent studies confirm Fried's findings. One is probably Fried. I probably sound so dumb saying Fried, but it's so much more fun. More recent studies confirm Fried's findings. One study focused on how anti-rap bias may impact jurors in criminal proceedings. The results were consistent with Fried's results decades earlier. The findings suggest that rap lyrics might influence jurors' decisions independent of their actual content. That is, the mere label of rap is sufficient to induce negative evaluations, even when holding constant the actual lyrics. The findings suggest that judges might underappreciate the extent to which the label of lyrics, and not the substantive lyrics themselves, impact jurors' decisions. The present findings suggest that judges should consider limiting the introduction of rap lyrics to instances in which the lyrics are highly probative of some relevant legal issue, and judges should realize that jurors might make inferences based merely on the genre of the lyrics and the stereotypes that they evoke. Yeah, so the idea that, if you're going to play the song, people can tell the genre, you're opening the door to what seems like studies show is an inclination to prejudicial thinking. So, and that's the Dunbar resources, the academic papers. In some, studies show that rap music is commonly viewed negatively and with an anti-black taint, and this negative bias is a danger to the fairness of criminal proceedings. In Broadnax's case, the state used his rap lyrics to reinforce and weaponize racial and anti-rap sentiments to argue that he would commit violence in the future, that no mitigation justified a life sentence, and that society would be better if the state killed him. This appeal stoked and relied on an anti-black and anti-rap biases that are common among jurors to get the result the state wanted, a death sentence. All right, so next argument is D. We've got the state weaponized cultural expressions common to rap to improperly portray Broadnax as dangerous and threatening. Many cultural expressions used by black artists in rap music carry meanings that differ from their usual associations. Like down bad, for example. Here, the state presented rap lyrics that contain black vernacular and hip-hop slang commonly used in black culture, but framed them as confessions of future violent intent. These lyrics were presented to mostly white jurors. The state weaponized culturally expressive language by distorting it into incriminating evidence of Broadnax's future dangerousness. For instance, the state presented several lyrics that included slang such as N.O.R.E. and gangster to portray Broadnax as violent and aggressive. But while these phrases may be interpreted as slurs, they take on different meanings within black culture. And this is from The Weaponization of Rap Lyrics in Court. That's by John Yeldham. Oh wait, the title's Art as Ammunition, The Weaponization of Rap Lyrics in Court. Nice. And then Dean James McLeod, freshman, writing prize. And there's a link here for that one. Oh, because he won an award with that. Oh, that's cool. Shout out to John Yeldman. So he submitted this for a scholarship opportunity? That's cool. It's cool to see someone so young, thinking and really doing this stuff. The N-word historically has been used as a racial slur, but the word has many meanings in rap, such as to differentiate urban working class black people from the black bourgeoisie, and as a term of endearment for a close friend. They say here, see, we've got Micah Thompson and Sierra Rahim, art as the prosecutor's weapon, the use of rap lyrics evidence at trial. Let's see. Using the term against Broadnax without any contextual explanation was highly prejudicial, given the deeply rooted negative connotations associated with it. Absent any clarification of its intended meaning in rap lyrics, its use served only to portray Broadnax as vulgar, disrespectful, and even violent, which ultimately weaponized his own cultural expressions against him. Additionally, the state presented Broadnax's rap lyrics as literal statements rather than cultural and artistic expression. Violent lyrics and rap genres serve a purpose to express identity. Many Black rappers have acted as street ethnographers, portraying experiences from structurally disadvantaged communities by adopting personas like gang members, hustlers, or everyday workers. Rap music for Black artists often becomes symbolic or fictional, rooted in storytelling traditions and serving as a form of social and political commentary. The state never acknowledged the cultural context of Broadnax's lyrics when presenting them to the jurors. Instead, it weaponized artistic expression by framing his lyrics as confessions of future violence and criminality. So there is a this is Section E, there is a judicial and legislative trend towards prohibiting the use of rap lyrics as criminal evidence. So hinting to SCOTUS, like, sometimes if there's like a circuit split on an issue, so different circuits, some of them think this, some of them think that, will be like, hey, can you resolve this? The idea that other courts and even legislation are steering in this direction, it's kind of like now is the time, like the moment is ripe to consider this issue. Prosecutors have been using specifically to prohibit it, not just to consider it, but to consider prohibiting it. Prosecutors have been using rap artistic expressions as criminal evidence to inject both racial bias and unfair prejudice into criminal trials since at least 1991. And this is poetic injustice. I like the way that's written. We've got courts are increasingly critical of this prosecutorial practice, imposing important limitations on it and frequently barring prosecutors from admitting rap lyrics into evidence. While Broadnax's lyrics were not admitted during the guilt or innocence phase, discussions of this trend remains important because the reasons courts are increasingly hostile to rap lyric evidence have important implications for how the state used Broadnax's lyrics. With greater frequency, American courts are holding that rap lyrics rarely should be admitted in criminal proceedings because of the prejudicial risk they pose to fairness. In rejecting the use of rap lyrics in this manner, courts consistently raise two critiques. One, that the risk of it, that any minimal probative value of the rap evidence is outweighed by the unfair prejudice that lyrics referencing violence, drugs, and other criminal activity interject into a trial. And two, the absence of any factual and temporal nexus between the rap lyrics and the charged conduct. We've got only, quote, only where the government can point to lyrics that communicate specific details related to the charged conduct is the court confident that evidence's probative value is not substantially outweighed by the risk of unfair prejudice. We've got from the 11th Circuit holding that a rap video was irrelevant and heavily prejudicial. Courts increasingly are translating their critiques of rap artistic expression evidence into holdings that such evidence cannot be admitted at trial due to its prejudicial effect. And we've got, let's see, here precluding rap lyrics as evidence in a murder trial, and then another example holding that inflammatory rap lyrics alone could cause a jury to convict. Oh, I like that. I like that because this is like, oh, they shouldn't have allowed these lyrics to come in, but you're not meeting the bar. The jury would have convicted anyway. Just because this was an issue. That's not the only reason they convicted. The conviction was sufficient. They had enough. But here they're saying inflammatory rap lyrics alone could cause a jury to convict. In this holding, they have that concern. That it's so powerful, so prejudicial, that it alone could do it. So, love to see that. Love to see that. The growing judicial trend is that rap artistic expression is not admissible evidence unless the government can demonstrate a factual and temporal nexus between the lyrics and the charged and alleged conduct. Let's see. We've got United States v. Sneed. Excluding rap video that did not contain references to the charged conduct. We've got State v. Skinner, holding that self-expressive fictional, poetic, lyrical, and like writings about bad acts, wrongful acts, or crimes generally should not be deemed evidential unless the writing bears probative value to the underlying offense. Finally, courts are not alone in placing barriers that prosecutors must overcome to use rap artistic expression as evidence due to the prejudice, particularly racial prejudice, that rap lyrics interject into criminal proceedings. In 2022, California enacted the Decriminalizing Artistic Expression Act. The act addresses the dangers posed by artistic expression evidence, particularly the racial bias injected into criminal proceedings through rap lyrics, by creating a standard for the admission of such evidence based on probative value and absence of undue prejudice. It also sets a presumption that artistic expression evidence is not admissible unless prosecutors can show it was, quote, created near in time to the charged crime or crimes. So this is interesting because we just had a bunch of decisions come down in the Dirk case, and I don't want to speak to any specifics, but I feel like one, and it was like allowed, but like subject to foundation at trial or whatever, but it was like years away. And others were excluded, and others are, I'm not making a ruling on that. I don't want to be held to specifics on the line by line because I don't really recall the decision specifically. But I think it was the Dirk case where, and that's California, which is why I'm thinking of it. It was way far away in time, but they're like, well, I don't know. We'll see at trial. So who knows? But anyway, it's supposed to set this presumption that artistic expression evidence is not admissible unless prosecutors can show it was created near in time to the charged crime or crimes, bears a sufficient level of similarity to the charged crime or crimes, or includes factual detail not otherwise publicly available. So, or I guess it's an or. So there you go. There's an or. This comports with the modern trend of courts requiring a factual and temporal nexus between the expression and the charged conduct. In conducting this balancing test, the Act requires courts to weigh whether a jury will treat the lyrics as evidence of defendant's propensity for violence or general criminal disposition, as well as the possibility that the evidence will explicitly or implicitly inject racial bias into the proceedings. So, a key goal of the Act is to prevent prosecutors from using rap lyrics to trigger racial biases among juries, and to prevent juries from concluding that a defendant has a propensity for violence or criminality based on rap lyrics. So, conclusion here. Despite decades of racially criminalizing rap music and linking that criminalization to Black individuals to argue their propensity towards dangerousness and criminality, the use of rap lyrics during a trial continues to plague the criminal justice system. This case exemplifies the racial prejudice that infects a criminal proceeding when the state uses a defendant's rap lyrics to capitalize on anti-rap bias, the misinterpretation of rap lyrics, and anti-Black bias triggered by rap music. The state used Broadnax's artistic expression to portray him as a young Black super predator without redeeming qualities who must be executed to protect the community. The state's use of Broadnax's artistic expression to trigger racial and anti-rap fears and biases was a dangerous circumvention of constitutional guarantees that must not be allowed to stand. So we have Charles Chad Baruch, Brandon Toby, and we've got Lucius T. Outlaw III. So there we go. That was the council that submitted this. And again, we went through this whole list. Let's scroll this on the screen like the credits reel here. Very, very nice long list here of different groups and organizations advocating on this issue. I think it might be interesting to read the brief. So Broadnax is I think if I see that name come up, like, oh, this is who SCOTUS is granting cert for today, and I see Broadnax's name on there, I think I'll remember that one. Sometimes, like, Martins and Smiths and, like, usual repeat names, I'm like, which case was that? I don't remember what case was what. Looking at Georgia Supreme Court case decisions, I think I'll remember Broadnax. So if I see, all right, cert was granted for the Broadnax case, we can look at the briefs. We can look at if there's any other amicus filed. We can look at those. We can look at the replies from the state. So pretty interested in seeing how that plays out. And again, the other arguments, I mean, we might see, hey, there's a whole issue with the guilt phase, and that might be interesting too, and has nothing to do with the lyrics. So we'll take a look at that. I really thought it'd be, and I do think it was great to read this. It was easy reading. I thought it was really grounded in, like, the big comprehensive picture, the how we got here and why now is the time, as more and more of these prosecutions seem to be popping up where prosecutors are trying to introduce lyrics at trial. We need something at the federal level. This would be a great time for SCOTUS to weigh in. So I think I saw earlier Doug was a little nervous about having SCOTUS weigh in. And that, I guess that could be a risk if they say, hey, well, if it discusses something mildly similar, it's fine. That wouldn't be the outcome I think a lot of us would want to see. So, yeah, Max, it was short and sweet. Yeah, it was nice. It was nice. And it wasn't too much. I was like, oh my goodness, there's going to be a lot of... I thought with like all these different cases, there'd be a lot of stuff for me to pronounce horribly. It wasn't too bad. Because a lot of the cases, I guess I just sort of skipped over the names. I skipped a lot of the case caption names and just read the holdings, but I don't think I messed anyone's name up too bad. I always love to not feel guilty about saying someone's name wrong. And yeah, Doug, good to see you. Good for you for always advocating on this issue. You know, you've been talking about, you know, Rap on Trial, I think I heard about because of you, as far as like the book. But of course, you talked about other cases as well. And Doug also threw in here that they were ready to use this in YSL with the rap expert, but never needed him. That was in reference to one of the papers we looked at earlier in this brief. And Dr. Dunbar would have been one of your efforts? I don't know. Dunbar. Let me see a picture. Would that have been at one of the 2023 pretrial hearings with camera feeds? Let me see. What day would that have been? Because what I'm thinking of is we saw some pretrial stuff, but some other stuff like Viverito's wasn't filmed. So we didn't get to watch that one, but we just had the transcript. Okay, so I'm seeing this quick thing. April of 2023. Dr. Adam Dunbar, a college professor who conducted several studies on rap lyrics and the potential impact they could have on a jury, took the stand, testifying about some of the findings he's made in recent years. I don't know if I remember watching this. I told participants, look, you're going to read a set of lyrics, and then you're going to have to make some judgments about the author of those lyrics. Participants were randomly assigned to learn that the lyrics were either rap, country, or heavy metal. So he's going into the study that we read a little bit about. Monday in court, prosecutors criticized the professor's research methods. So you didn't feel for studies about rap you needed to include more than 4% of Black people? Betsy Weintraub asked. Why? Why not go to a different platform to find more people? Different platforms aren't necessarily better with balancing racial demographics. So, I don't know. Maybe I'll pull up the old YSL content playlist and go back towards this date and see if WSB TV or any of the other channels have that published. Because that'd be definitely cool to watch. So, oh, so his computer was in front of his head the whole time. All right. I think we should go back and watch that. This is just like a tiny little clip up here, but I'll look for... So what I do when I see stuff like this and I'm looking at thumbnails of old hearings is like, and it gets hard. Oh, there you go. There he is. There's his head. We've got to find this full thing. I want to watch that. Let's pull this up bigger.
Rap lyrics and the potential impact they could have on a jury, took the stand, testifying about some of the findings he's made in recent years.
I told participants, look, you're going to read a set of lyrics, and then you have to make some judgments about the author of those lyrics. Now, participants were randomly assigned to learn that the lyrics were either rap, country, or heavy metal. What participants didn't know is that they were all reading the same lyrics from a 1960s folk song called Bad Man's Blunder. And so what I found was that when the lyrics were represented as rap music compared to country or heavy metal, participants viewed the songwriter as having worse character and a greater criminal propensity.
Oh, they're gonna get me. If this is like stream unavailable, I'll have to cut that little tiny part out. It can be really annoying. they will get me for like a visual and audio 2 seconds and say this is blocked in certain countries.
Thug, whose real name is Jeffrey Williams, have argued rap music is on trial, essentially claiming that prosecutors took portions of Young Thug's songs to help build their case against him and his alleged associates. But prosecutors say the songs support their allegations that Young Thug was the head of
Did that prosecutor leave the office?
Criminal street gang accused of committing violent crimes across the city. Defense attorneys call those claims baseless and claim YSL stands for Young Stoner Life, Williams' record label. Today in court, prosecutors criticized the professor's research methods.
So you didn't feel that for studies about rap, you needed to include more than 4% Black people? Why? Why not go to a different platform to find more people?
So different platforms aren't necessarily better with balancing racial demographics.
So there we go. Yeah, that'd be fun to watch that whole little thing. I'll look for it, add it to the list of things to do, and that'll be a nice casual one. I mean, it's we know the outcome. We know that Doug got an acquittal for his client. Bravo. We know the outcome there, but that'd be fun to revisit. And next up, you guys, today that does not start the appeals and arguments and issues. We're going to watch this. I'm pretty excited for this because when I scrubbed through it, look how much, there's a lot of judge activity here. So I think we're going to get a lot of questions on this. And this is going to be related to Daryl Ewing and Circe. They were co-defendants. They had their convictions overturned. And when the state went to rebring the case, they sat on their hands for like years and years and years. And the defendants, I think they filed like an omnibus petition for delay because of like undue delay, what are we doing? And then the judge agreed. The judge agreed and dismissed the case without prejudice. But the state's appealing that decision, and I want to hear what they say. We'll go over some more detailed background on the case against Ewing and the process of how we got here. And then it looks like they might move on to another case about an hour in. So it looks like he's back up for rebuttal. And it's like an hour of oral arguments, and we'll talk about the case for like 15, 20 minutes to get some grounding before we listen to what they're arguing here. So I'm excited to hear that. Hope you guys want to join. I think this is set to redirect there. It's going to start in about 30 minutes. So I'm going to take a break, take a comfort break. I happen to still have a clip of lyrics that I think would be the right thing to take us out with. So a little throwback to the YSL trial and lyrics. Going to send you out with this and hope to see you at our next stream in 30 minutes.
Associate of YSL released a song on YouTube titled Slime Shit, where the lyrics state, hey, this is that slime shit, hey, YSL shit, hey, killing 12 shit, hey, fuck a jail shit, hey, cooking white brick. I'm not new to this, hey, so I'm not new to this, hey. I'm so true to this, hey. I done put up a whole slime of 100 licks. Slime or get slime. I'm in the VIP and I got that pistol on my hip. You praying that you live. I'm praying that I hit. Hey, this that slime shit. Fuck the police. Fuck them in a high speed. 100 rounds in a Tahoe, I'm prepared to take them down. Got banana clips for all these niggas acting monkey. This, that slime shit. This, that mob shit. Fuck the judge, YSL. This, that